Hello everyone, and welcome to the first of our video tutorials on judicial precedent. Judicial precedent is a topic all about how judges use decisions in previous cases to help them make decisions in cases in front of them today. So it's reasoning by analogy. And in our previous topic, we were looking at statutory interpretation, which was looking at how judges interpret and understand Acts of Parliament, whereas this topic we're looking at how judges use past cases to help them with cases in front of them today. So if we have a look at what judicial precedent is then, you can see here that the slide says that precedent refers to the source of law where past decisions of judges create law for future judges to follow. And it's based on stare decisis, which means to stand by previous decisions. And what we're saying with that is once a point of law has been decided in a particular case, that law must be applied in all future cases containing the same facts. So if you imagine here on this little picture, if this is a case that was set today by the Supreme Court, we would want to follow that decision in all the cases that follow it. And as I've just said, judicial precedent is based on some Latin, stare decisis, and stare decisis means to stand by what has been decided. And if you think about in law why we might want to do that, why we might want to stand by a previous decision, hopefully you'll be thinking that that's going to lead to fairness. It's going to hopefully lead to justice in a particular case. Because we'd all think it was wrong if a decision was made today, and then a completely different decision was made tomorrow. That stare decisis is going to help us hopefully achieve fairness so that similar cases are treated in a similar way. But it's also going to provide some certainty because you're going to be more able to advise your clients if you can say what's likely to happen to them based on a previous decision. And in order for precedent to operate properly, we need three things. We need a court hierarchy, ratio decidendi, and we need law reports of past decisions. And if we don't have all of these three things, precedent won't work. So it's really important that we have all of them. And in this video tutorial today, I just want to focus on court hierarchy. So how court hierarchy helps the doctrine of precedent to work. So I've got on the next slide a diagram of the court hierarchy. We've got the Supreme Court at the top, the Court of Appeal, which if you remember has a civil and a criminal division. We've got the High Court. And then the reason we've got these two columns is that these ones are the criminal courts and these ones civil courts. Tribunals are separate. They run alongside the court system, but they are on this diagram. So the reason why a court hierarchy is so important to judicial precedent is that it establishes which decisions are binding on which courts. And in general, the higher the court is in the hierarchy, the more authoritative its decisions are. So higher courts generally bind lower courts to apply the same decided principle or to apply the same ratio as they have. So in general, the Supreme Court binds the Court of Appeal, and the Court of Appeal binds the courts below. And in general, the higher courts bind themselves. And what that means is, usually, once a court has made a decision, it has to stick with that decision. And the reason for that, of course, is if the Supreme Court made a decision, but then changed its mind tomorrow, and then went back to its original decision the day after, and then changed its mind again, we would lose all faith in the decisions that it was making, and the law would become quite uncertain and a bit higgledy-piggledy and a mess. So in general, we want certainty in the law. So when a court has made a decision, we want it to be followed. Of course, we want to be able to change it as well, if possible, and there are some exceptions to those general rules. But for now, in general, you need to be aware that the higher courts bind the lower courts, and in general, the higher courts bind themselves, which means that they usually stand by their own decisions once they've made them. So we're going to have a look a bit closer at each of the courts in turn and looking at the rules on who binds who. And the reason we have this binding hierarchy, of course, is that in order to have order in our court system, you need to know who the most authoritative person is. And you can think about that in your own workplaces or in college. You've always got a boss at the top, and then maybe managers beneath them, and then normal workers. And the reason you have the hierarchy in any sort of workplace is to give structure. And it's so that everyone knows where they stand, everyone knows what rules they're following. So we're going to start off then by having a little look at the Supreme Court. So on this next slide, I've got a picture of the inside of the Supreme Court for you here. And the Supreme Court, we know, is the highest court in the UK for civil and criminal cases, and it only deals with cases of greatest public importance that are going to affect the population in general. So for that reason, it doesn't hear that many cases. On average, you're looking at 50 to 60 cases per year, and they are the cases of greatest public importance. This court was created by the Constitutional Reform Act 2005, and it replaced the House of Lords as the highest court. And when we looked at parliamentary lawmaking, we looked at the reasons for that. So the House of Lords is part of Parliament, and it used to be the highest court as well. And that conflicted with separation of powers, with the fact that the legislature and the judiciary were overlapping. So we created this brand new court, which is separate. It has no part of Parliament at all. And we've also looked at this court. We looked at a court case, really important one, on the application of Miller and the Prime Minister from 2018. That was a really important case. Brenda, you can just about see her there. She used to be the president of the Supreme Court. It's now Lord Reed. But that was a really important case because the Supreme Court there were reviewing the actions of Boris Johnson when he tried to prorogue Parliament. And I think that's just showing you it's a nice example that the Supreme Court is hearing extremely important cases. And that case was, about whether the Prime Minister had acted unlawfully, which of course we know that she found that he had. So if I move on to the next slide then on the Supreme Court, as I've already mentioned, it is the highest court in the UK. But just to be aware that at the moment, whilst we are still part of the European Union, we are bound by the European Court of Justice. So when we studied EU law, we saw that the European Court of Justice, that law is supreme on UK law at the moment. We looked at Costa and Annell, Factor Tame, and Van Genden Loos. But if we're just looking at the UK, which we are at the moment, then the Supreme Court is the highest court. We already know it's got civil and criminal jurisdiction, so it's hearing cases from both of those areas of law. And as it's the top of our UK hierarchy, it binds all of the lower courts. And as I said in the introduction, it usually binds itself, meaning that once it's made a decision, it usually sticks with that decision, but there is an exception to that. And we will look at this later in the topic in another tutorial. But just so you are aware, it can use what we call the UK Supreme Court Practice Directions 3 and 4 to depart from its previous decisions, which basically means it can overrule itself, quote, where it appears right to do so. Now, the practice directions I've put here in brackets, it used to be called the 1966 practice statement. So if you see that appearing anywhere, that's what that means. So what we're saying is this court binds all lower courts and it usually binds itself, but in exceptional circumstances, it can get rid of or overrule its own previous decision using this practice direction where it appears right to do so. So if we move on then to the next court, so I'm going down in order from our highest court right down to our lower courts. So the next court is the Court of Appeal, and there's a little picture for you there. And if I just go on to the next slide, clue is in the name here, of course. It's a Court of Appeal. It hears appeals. And remember that the fancy name for that is that it is an appellate court. So it doesn't ever hear cases for the first time. It is not a court of first instance. It is an appellate court. And similarly to the Supreme Court, it has a civil division and also a criminal division. And because it's beneath the Supreme Court in the hierarchy, it is bound by the Supreme Court. So it has to follow any decisions above it from the Supreme Court, even if it doesn't like that decision. It's got no choice, it is bound to follow it. Each division binds all the courts below, but the two divisions don't bind themselves. So what I mean by that is the civil division of the Court of Appeal and the criminal division of the Court of Appeal don't bind each other because they're totally different areas of law. So they operate separately. Just like with the Supreme Court, each division is usually bound by its own past decisions, but there are exceptions which we're going to look at later in the topic in Young and Bristol Aeroplane. And in Young and Bristol Aeroplane, we get the exceptions to when the Court of Appeal can avoid its own previous decisions, but usually, like the Supreme Court, it is going to follow them under normal circumstances. So if we move to our next court down in the hierarchy, we've got the High Court here. And the High Court has three divisions, and we've seen this previously. It's got a family division, a chancery division, and QBD, which stands for the Queen's Bench division. And those divisions deal with different types of law. And they are courts of first instance, meaning that they hear new cases, but there is a divisional court within each of these divisions, which will also hear some appeals. And you can see there that the divisional appellate courts bind the courts below and generally bind themselves. And the High Court binds the courts below, but doesn't bind themselves. Okay, so it's telling you that the first instance sections don't bind themselves, but the appellate section in each of these will bind themselves. And then if we go down to our next courts, we've got the County Court and the Crown Court. Now these are on the same level in terms of hierarchy, but remember that the County Court is a civil court and the Crown Court is a criminal court. But I'm dealing with them together here because the same rules apply. So these are courts of first instance, which mean that they hear cases for the first time, and they don't hear appeals, their first instance courts. There is an exception to that, just to say that the Crown Court does hear some appeals from the Magistrates Court, but generally it is a court of first instance. And these courts, because they're quite low in the hierarchy, they bind nobody, but they are bound by all of the courts above them. And then at the very bottom of our hierarchy, we've got the Magistrates Court. And this mainly deals with criminal cases, and about 98% of our criminal cases are dealt with here. And this court, because it's so low in the hierarchy, it binds no one, and it is bound by all of the courts above. And it is possible on this exam that you could get a 5 marker on the hierarchy of the courts and how they are necessary in judicial precedent. So it might be an idea to just pause this video at this point and take some notes on what you would put into this answer. And in order to answer this question, you would basically just do what I've talked you through there. I think it's logical to start with the Supreme Court and go through all the rules of binding from the Supreme right down to the magistrates at the bottom. So that's the first of our videos on judicial precedent.